It is 50 million cases pending. I don't think we should just brush aside just because we are going to have it is replaced by the old criminal laws by the new criminal this now coming we are having it now. I don't think. But as we see, like we have law students, the most important thing is that you may become a lawyer or may not be, but you may be law expert or something. Because you must know how to present your case. You have to be smart enough. Because as I said, law is nothing but is the interpretation of the case. But ultimately the central thing, the fundamental thing of the law is to deliver justice. If you violate this one, then you will just do it, you will just twist and twist in order to suit your own case of presentation. So the fundamental of the law is to deliver justice. That is the main thing. Here what we are having about, just before we are talking about opposition.
Some of the are two institutions that we respect, and will respect. They are going to bring so much changes in today's society, maybe in social, political, in all other fields. If you look at history, if you look at world over, there are so many examples of big changes in society which has been brought about through a very proactive press, through very smart, intelligent, and very dedicated and very motivated journalists, men and women of letters, and also what is there in society which law doesn't govern? Law, it's through law that we understand and things are explained and things are reasoned. So that being said, my senior Sri Okendit, he has laid before you a very huge issue. He has talked about 371A, he has talked about framework agreement, peace talk, the political issue in Nagaland. However, I will be talking on a very, if he was talking about this big as an issue, I'll be compartmentalizing my issue to just this part. So I will be able to be as ambitious as he has laid the ground rules. But I'm happy that in the end he commented that he's happy because police and press and the law and lawyers, may I say, are usually in different. They are usually generally adversarial. So they are usually in different positions. So I'm happy that he admitted at the end that he's happy that criminals, that the old criminal law has been replaced by the new laws. And on that note, I will try to give my short take on the new criminal laws. I would begin, my voice is okay? I'm not too loud. I would like to begin by quoting someone who we often quote, Martin Luther King Jr. He says, true peace is not merely the absence of tension. It is the presence of justice. So, on that note, the criminal justice system, it is to the criminal justice system that the moral arc or justice in society is maintained. The criminal justice system in India, the linchpin, the three pillars, if I may say, of the criminal justice system in India was based on the IPC, that Indian Penal Code 1860, CRPC, that is Criminal Procedure Code 1973, and the Indian Evidence Act 1872. Students of law must be already familiar with that. So, but to keep it short, more than 150 years have passed since this act has been passed. There have been several amendments, some very major amendments. Also, there were so many law commissions, so many court judgments, and so many committees have talked on these codes. And amending them or bringing a new law has always been on the cards through many decades. And last year, in December 2023, the Parliament passed these new criminal laws, which we know as the BHARATIYA NYAY SANHITA, which can roughly translated the Indian Justice Code, the BHARATIYA NAGARIK SURAKSHA SANHITA, which could be Indian Citizens Security or Safety Code. BHARATIYA SAKSHYA ADHINAYAN would be literally Indian Evidence Act. So the reasons that this code was passed, as it's clearly given out in the handouts and also mentioned by previous speakers, is of course these were colonial laws. These were vestiges of the British rule. And of course times are changing. We live in a very different world now than that was 100 years ago, 50 years ago, or maybe even just 10 years ago. Science and technology has developed so much in the world now. The quantum and the size of progress and the technology we cannot envision. So our laws have to be based with it, and also the virtue of having a victim and citizen-centric laws, a restorative law, a law which caters to its people, and of course. Corollary to it, systematic, simple, transparent, fair, and just law. I mean, these were basically the parameters on which the new laws were envisioned. You are all aware, we have a thing called under trial prisoners. Students of law will know those are prisoners whose trial are still pending in the court, but because some judgment has been given, they are still in jail. So they say, as per data, 75% of prisoners in prisons are under trial prisoners. So just because of justice delay, they are still in prison. And there is 85% dependency of cases in the court. So these are serious issues because of which such these new laws have been planned. So for this, so many training sessions to the police, to the law, to the legal fraternity, conference, seminars, and awareness has been carried out by the government. And I think today's seminar has been organized towards this end. So quickly, as per my mandate, I will try to rush you through the 3 laws. I don't know whether you'll be able to bear with me, but I'll start with BNS, that is the BHARATIYA NYAY SANHITA, which is the replacement to the Indian Penal Code. So what this Indian Penal Code, or what BNS does is, this is a code, this is a law book, where it explains what are the crimes. For example, theft, for example, murder, for example, robbery, extortion. It explains how are these crimes, and then it gives punishments, the quantum of punishment as per the severity of the crime. So that's the BNS for you. So in the new BNS, they have made new changes. Basically, as the previous speaker has stated, these laws are not a complete change or a complete overhaul. They have modified some laws. They have kept some laws as it is, and they have shifted some laws. They have changed the chapterization so that to make it more organized, more systematic. So in some cases, the number of sections have increased. In some cases, it decreased. So fine-tuning of the code. So in BNS, so the new BNS, what it has done is it has made the law sequence very systematic. It has started with according to the priority of crime, according to the severity of crime, they have compiled and they have made it stepwise. So, for example, chapter 5, the first group of crimes they mention is on women and children. So obviously the government gives a lot of importance on crime against women and children. Then they go to body-related crime like murder, like assault, and then of course crime against state. So crime against women and child, the government has, I think, highlighted it, and they have given a very severe punishment against such crime. They're very stricter penalties, from life imprisonment to even death penalty in case of gang rape below 18 years of age. Even the age of child has been increased from 16 to 18, which is in line with the POCSO Act. And so that's one. And they have made a comprehensive measure against sexual harassment. And they have also made a new additional law of crime by deceit, that is for marriage, for employment, for promotion, things like that. And they have made they have also highlighted that a trial of women related in crime should be done in camera, so to maintain the sensitivity to the privacy and confidentiality. So that's one. And also in some new crimes, taking into aspect the contemporary challenges in society, they have included, for example, organized crime. Organized crime, they have explained it as any unlawful activity including kidnapping, robbery, extortion, economic offences, cybercrime, drugs related by persons or group of persons or an organized syndicate. So now in this modern age, we have a lot of issues of economic crimes, money laundering, and issues like that. For example, so that's why the need of course organized crime and terrorist act and terrorism has also been included in the new code. We have a separate unlawful activities prevention act, but still taking into aspect the menace of terrorism, they have also included. One very special thing in this, unique thing in the code, which they have included, which was not there in the previous law, is community service. So this goes towards reformative approach of justice. So, for example, petty offences like petty theft, public drunken misconduct and defamation, they will, instead of sending them to jail, they will give them mandatory public service, which the court will decide what type of community service, which the court will decide. And of course, there are other crimes like mob lynching, snatching, ATM theft, place of worship, death by negligence. So I won't take too much time there. But so basically, taking into aspect the new crimes, they have added some new laws. So that's your BNS. That is one code done. So we have two more to go. The next code is BNSS. That's your BHARATIYA NAGARIK SURAKSHA SANHITA. So that's your procedure code. So the first one was to do with crime. I mean, how is crime explained? What kind of find out? This is basically a procedure code where it explains from the point of registration of a crime till the judgment is given. So it comes to police, then police investigates, then police gives the charge sheet, then it goes to the court case or trial, and court gives the judgment. So till the end. So that process is given in the previous the criminal procedure code. Now it's BHARATIYA NAGARIK SURAKSHA, so citizen safety. So the procedure itself, by its name, wants to give out that this procedure is for the safety and security of the citizens. So it is pro-citizen, pro-people. It seeks to be a pro-citizen and pro-people's procedure. So I'll quickly, it's a big code, it's a big book, but I'll try to just go concise in few lines. So first, there's investigation-related reforms. So investigation means police investigation. So what reforms? What for the police investigation? There is a concept of zero FIR or eFIR, as electronic FIR. So which is a new concept. Of course, it was there a little bit in the previous code, but what this does is you can file an FIR in any police station. I mean, the crime that occurred in some other police station, but you can still go to through this process of zero FIR. You can file a case in maybe if the incident happened in Kohima, you can still file in Kohima. It's kind of thing. So, and concurrent to it, there's a thing called EFIR, electronic FIR. So you can file an FIR electronically, email or WhatsApp, things like that. And so that's one. So it's very convenient for the public. That's one. Two, prosecution. So the court seeks to have a separate prosecution directorate. So this is for the legal law students. So basically, law has become very complex now, and especially after new crimes, after technology-related issues and dependency cases, you need a very robust and very active prosecution. So it seeks to have a separate director of prosecution who will study the cases and charge it in submit to the police and look at the legal ramifications and look at the legal issues and give a strong case to the court. So that's what it has to do. So that's to do with capacity building, I guess. Then it also emphasizes to have a very strong forensic experts. So especially for crimes above 7 years. That means if you have a crime of 7 years, that would be very serious crimes. So for that, the code says that compulsorily the forensics team should go to the spot, do the forensics gathering, forensics analysis in camera. So this is a very modern concept of policing. Also, it also says that the maximum number of days after all pending a charge sheet. The charge sheet is the, I'm sure you're aware, is the final case that the police submits after the investigative case. Should be done maximum before 180 days. So that's how it tries to speed up the cases. And for rape cases, the court says, the law says that within 2 months the charge sheet will be submitted. So that's one. Now, safeguards against arrest of public. In the previous code also, there are so many safeguards of arrest to the public that a woman should be arrested after sunset, and a person arresting should state, a police person arresting should state his name and for what he's arrested, all that. So, but in this code, they have added some new additional safeguards saying that it indirectly says that arrest is not mandatory. I mean, if for maybe not except for very serious crimes, if the accused listens to the police and if he agrees to come whenever is required, arrest is not necessary. That's what the code tries to convey. And all police stations should have an officer who should list out a notice of everyone who has been arrested, his name, his village, and his phone number, and his relatives, his friends should be informed if he's arrested. Handcuffs shouldn't be, is not permitted except for very serious crimes. So those kind of safeguards against so that people are not harassed by police. So this is given. There is a point of attachment of property, but I think that may not be. So I'll leave that. So that's one. Now the second point is there are some victim or the accused centric reforms which the court tries to emphasize. So, for example, the copies of the FIR, the police report, the police document, police case diaries should be given to the accused, a copy of the accused or the victim before 14 days of his production to the court. That's very technical, but basically it says that whatever FIR document you have, a copy should also be given to the accused or the victim before 14 days. That's basically what it says. And also it says that the progress of the investigation of the police should be given to the victim by 90 days. So that's another, and if the prosecution is planning to withdraw or discharge the case, the victim opinion should be heard. So those are pro-victim and pro-accused reforms. And also the statement of the victim, the statement of the accused, the witnesses can be, it says, taken through audio, visual, and electronic means. So they don't need to come to court. They don't. So that possibilities is given. For example, rape victims' statement should be taken by a woman magistrate or a woman. There is a mandatory bail clause for prisoners, for accused, for whom it is a first offense. For example, it's given that if a prisoner, if it is his or her first offense, then the court can give 1/3 of the sentence. So those schemes helpful to the accused is there. There is a witness protection scheme which is there in the Western countries, which is also engaged by this group. One very important, if not anything else, this code will be known for this. That is the technology part. It opens the gate for use and harnessing of technology for justice. But this will be one overarching theme of this procedure. The code uses the word audio, visual, electronics, I think, yeah. It is used 35 times in the code, and mobile phone. The use of mobile phone to take videos of search, of seizure, of arrest has been mentioned several times in the code. So technology shouts in this code. So for example, like I said, EFIR, statement of witnesses, accused, experts, prosecution, police, can be taken through audio, visual, electronic means. Documents and reports can be submitted through electronic means. Summons, warrants, notices, which was erstwhile issued through post office, can be now issued through WhatsApp. I mean, that is also that is given. Search and seizure by police should be mandatorily recorded by video, and they also mention through mobile phone. So, and it specifically mentions that the trial proceedings in a court should be videographed. So this use of technology, use of audiovisual electronics ensures that time is saved, there is no delay, there is confidentiality, there is privacy, and it's convenient for the public. So this is one overarching theme in the new code. And then another very important part of this code, it gives specific timelines. I think in 20 or 30 cases, it gives exactly like by so and so much days this should be done. Like, for example, medical examination report should be given before 7 days. Information to the victim of the status of the investigation should be given before 90 days. Framing of charges by the magistrate, by the court, after the first hearing should be done before 60 days. In absentia, trial can be done before 90 days. After 2 consecutive warrants and advertisement in newspaper, after 30 days, the trial can start. Only 2 adjournments is allowed in any hearing, and judgment should be given before 45 days of the last hearing. So the exact number of days it gives, so it will have the police and the courts have to be always stand on the toes, given such exactitude of time. There are other new reforms like plea bargaining, summary trial, trial absentia, but I think I will not give that. But there are some. So all this plea bargaining, summary trial, trial absentia, it tries to bring less inconvenience to the victims, to the accused, by giving quick judgments and early judgments. So the last code is, the third and the last code is your DSA, that's the Indian Evidence Act. So Evidence Act is a small code, so what it does is, when a court sits in judgment, it requires certain facts, it requires certain evidence. I mean, the court cannot listen or base its judgment on hearsay or anything that is there in front of him or her. So it requires, so the evidence, the facts should be proper. So this code, this book explains how evidence and facts should be relied upon by the court. So again, one important thing about this code is electronical and digital evidence. So again, going back to technology, so there is a term in the code called document. The document earlier were files, were papers, were applications, were books, or were orders. But now the document includes electronic or digital record also, and that means it includes logs in the server computer, data in the mobile phone, in the cloud, in websites. So all this information and data is also taken as a document by the court. So it becomes, I think, in today's age, documents or correspondence are all done electronically. So this paves the way for police to carry out this investigation in a much convenient manner. And this is another revolutionary change in the code. And similarly, evidence, like I said, electronically given statements given electronically, electronic and digital records are also considered as evidence. So those are things, students of law, I think even journalists will know for journalism it's primary source and a secondary source. For law, I think it's called primary evidence and secondary evidence. So primary source or primary evidence has more weightage than a secondary source or a secondary evidence. So electrical and digital records, erstwhile it was secondary evidence or secondary, but now it has become primary evidence. So, and also, for example, especially in computer or network related data, files are created simultaneously in different channels. For example, say you upload something in YouTube, so immediately the data will be there in your computer, in your mobile phone, and in the YouTube channel. So those kind of things. So all these multiple files that is created are all primary evidence. So that's what the court says. So that is one important thing. There are several smaller reforms like the terminology of expert has been widened, accomplished testimonies, but so that's basically, but that's the key change in the third act. So that finishes my 3 acts, and I hope I have been succinct. To conclude, I would just like to repeat what Chief Justice, our dynamic Chief Justice D.Y. Chandrachud had mentioned just last month, I think, where he says that the present transition of criminal justice legal framework, these 3 new laws, is a huge transition for the new age, he says. He says that criminal law directs the moral arc of a nation. And he highlights that the importance of technology, infrastructure, and capacity building for us to be able to implement this law in letter and spirit. He also says that there's no finality to laws and its implementation. So we should be always ready to embrace positive change, adapt and improve to meet contemporary challenges and needs. The aim, the target being justice, balancing the interests of the victim and the accused. With this, I thank you for your time and thank you for this privilege. Thank you.